All right, welcome. I'm super excited to have you here today at our seminar. It's about estate and legacy planning, how to avoid the three biggest mistakes in estate planning. Thank you for taking out time to be here this evening. You could have been anywhere else, but you chose to come. So I'm excited. My name is Attorney Jumoke Oladapo. I know it's a mouthful, but you can simply call me Jumoke or Jimmy. Alrighty. So thank you for coming again. We'll be here for about 2 hours. We're going to respect your time. And everything we discuss here somewhat will be confidential. Somewhat. It's not confidential really because it's going on YouTube and Facebook. But we're going to discuss some more about housekeeping in a short while. So I'm an estate planning attorney. I'm also an immigration attorney. And this presentation is hosted by Ivy Law Office. Ivy Law Office is located in Greenbelt. Our office is across the road, 6305 Ivy Lane, Suite 605, Greenbelt, Maryland, 20770. We've been in operation for about 14 years, and we're excited that we did not go with COVID. We're still alive and well and thriving. So the best way to make the use of your time is to turn off your phone. So I'll put it on silent. We want to avoid distractions as much as possible, and that's the best way you're going to learn. You deserve this time for yourself and also for your loved ones. I want to say welcome to the people online. Thank you so much for taking our time to join us this evening. We're excited you're here with us. I hope you'll learn a lot today. You deserve this time as well for yourself and your family as much as possible. Please focus so that you'll learn a lot this evening. So for some housekeeping, this is an educative session. So because we're going online and people are going to be listening, for those in the room, please don't give personal information. If you want to ask a question towards the end, don't say your name, all right? So that people will know who is talking and thankfully nobody's seen your face, all right? This forum also does not create attorney-client relationship until you sign that dotted line called engagement agreement. That's when you'll become a client. So please bear that in mind. Questions are all going to be answered at the end of the session. Please, we have a notepad in your folders. You can write down your questions, and I'm going to address the questions at the end of the presentation. We also have a green worksheet. You'll find a green worksheet in your folder. This green worksheet, I would like you to make the best use of it this evening. First of all, please complete it. The first section will be your name and some of your information. Those information are going to be treated as confidential. We're not sharing it with anyone. So please give us as much information as possible so that I'll be able to connect with you after this meeting. The second section, we're going to use it as an interactive thing. So while I'm presenting, I'm going to be asking you a question like, so based on this, would you want to keep your family out of court? If your answer is yes, please check this box. Then you'll check that box and we'll go through those. Anything that relates to you, please check the box so that at the end of the day you'll know whether this is a thing that's worthwhile for you or not. The next section are some of the other services or some of the other ways we can be of help to you. So you'll check the next step box as applicable as well. Then you give us a little survey. How can we assist you better? How was this workshop for you? How was this presentation for you? At the end of the meeting, we're going to get this back from you. All right? And when you give this to us, we're going to give you a gift certificate. And I'm going to talk about it more in a few minutes. All right? And we're going to give you some other stuff as well. For coming, we want to say thank you, and we'll share some more gifts with you. Also, would like you to stay tuned to the end because you're going to get the golden ticket, which is what I was going to say earlier on. When you turn in your green worksheet, we're going to give you a gift certificate. We're calling this golden ticket. The gift certificate is going to be towards a planning session, which is a complimentary one-to-one meeting with me. It's a 2-hour meeting. We'll get to talk more about yourself, your family, your assets. What's this all about as relates to you? And this is going to offer it for you at a very minimal price. Also, we're going to give you another gift certificate. This is $750 towards a planning session. This is $250 towards any of the services you choose, any of the services you choose that are eligible for it. All right, and it's going to be like a credit towards if you decide to use our services. So those are our gifts to you. If you sign up for a family wealth planning session, if you sign up for a family wealth planning session, you get a digital asset checklist. You'll get a $250 gift certificate. And yeah, all righty. And we'll share some more information later. So, golden ticket is coming at the end. So, a little about our office. As I said earlier on, our office is Ivy Law Office. We specialize in immigration law and estate planning. We've been in operation since 2010, and thankfully, we're doing well. Through these years, we've been a blessing to a whole lot of people, thousands of people. And as a result of that, we have some accolades. I'm not bragging, but these are just a few. We've been named as a lawyers of distinction. We've been given the top 10 best attorneys, 10 best attorneys in Maryland for immigration law. We have probably over 85-star reviews on Google, which is not made up. They're not made up. They are real people giving testimonials about how we've helped them. We are top attorneys in AVO, and for estate planning, we are personal family lawyers. So it's not about family law, it's about estate planning, but we have a special training to offer estate planning to people in a special way to make it worthwhile. So we're not just document attorneys, we're not just traditional attorneys. We do our estate planning in a special way to serve our community. And one of it is offering this educative session to serve our community better. Before we go on, I wanted to find out how you got to know about this event. So, thank you again for coming. Who got to find about this event through a mailer? No. Through Facebook, a Facebook ad. One. How else? Email, e-newsletters. Email. Are you subscribed on one of our emails?
Recently, yes.
Recently, okay. So through email, through our e-newsletter, probably email, that's it. How else did we advertise? Through personal invitations? No. All righty. So thank you for coming. Thank you for seeing it on Facebook and deciding to come. And for those on online, please put a chat. How did you find about us? How did you find out about us? Put that in the chat box. We'd love to hear from you as well. All right. And thank you for coming, for getting our emails and responding. This is the personal me. This is my family. I'm married. I have 3 daughters. One of them is still a minor, and I have 2 in college. And what this brings, what this all means for me is that when we plan for the people we love most. It's not just for us, it's for them. Because we don't want to leave a mess for our families or our loved ones. So that's my why. We have a wonderful team of people that work with us at Ivy Law currently. So I'm the managing attorney and founder of Ivy Law Office. We also have Attorney Wilberforce. We have support staff, Miss Moji, Miss Princess, that's Miss Princess over there, and Miss Taya, she's with us as well. I think she's at the door right now. So these are our staff members in-house, and we have other people that work outside the office. So we all work together to create excellent client services for our clients. And for estate planning, our motto or our magic statement is this. We want to help our clients make sure that their families are kept out of court and conflict in the event of incapacity or in the event of death through proper comprehensive estate planning. We want to keep you out of court. We want to keep you out of conflict. We want to keep them out of conflict. We want to keep them out of conflict in the event of incapacity or death because they've done a comprehensive plan that will work when it's needed. A lot of people do plans, but the plans may not work for them. And we'll talk about that in a few. So for the people in-house, I want to ask this question. Do you currently have a plan? Have you done any form of estate planning before? A will? You did something before? What's that?
I have a will.
You have a will. Okay. A power of attorney, healthcare directive, trust. We'll touch on some of this legal documents as we go along this evening. And if you don't have one, if you have one, or if you don't have one, why not? Yes. Does this fall into any of the reasons why you don't have one? I'm too busy. Yes. Too young. Maybe before now, you used to be too young. All right. Or maybe you think it's too expensive, or you don't even know how much it is. And just have it at the back of your mind that, So these are some of the reasons why people don't have. All right. Does it resonate with any of us? And it resonates with one person? I would like to have feedback. Does it resonate with you? Any of this?
Yeah, that's why I'm here, because I feel like I need to get this done.
All right. How about you? Does it resonate with you? Somehow. All right. So I'll love your participation when I ask for feedback.
Okay.
All right. What questions are there? If you have one, why are you here? Is it because you want to have a better understanding of what you did? Is it because you did an online legal document? Or because maybe your plan may be outdated? Does it fall into any of those reasons?
No.
Ma'am?
Yeah, better
Which one? Which one of this?
understand.
Better understanding. Okay. Which you'll get today. So for those who don't have, I want to address some myths or fears why people don't. All right. So one of the biggest fears is this: planning for it will hasten its occurrence. I know people that this is what they're dealing with. They don't want to put a plan in place because they think when they put a plan in place, particularly when you talk about a will, then I think maybe they'll pass away next week. But no, it's a fair, but no, that doesn't happen. The fact that you have your plans in place doesn't mean you're going to pass away soon thereafter. You know, it's just like having what's it called? A car insurance. You know, the fact that you have a car insurance doesn't mean you're going to have a crash the next day. Am I right?
Right.
All right. So if this is unfair for you, please cross it out because it's not correct. These are some other myths. It's for the old folks, the retired folks, or the seniors. I still have plenty of time because I'm not old. Maybe I don't have enough, or it's for the wealthy. Does that sound resonate with anyone? Or maybe you think a will resolves everything. You know, those are some of the biggest myths about it. I spoke with someone some time ago, and the person is about 80 years old. And it was like, I still have time. I'm like, really? Yeah, that's my desire for you, that you still have some time, maybe another 10, 15 years, but you don't know. You're already 80, 80, and you're not making plans and you're complaining. And I was like, these and this and this, you told me, and yet, you're supposed to put a plan in place and you're telling me you're not ready. When are you going to be ready? But it's not for the old retired folks, or it's not for the people that are nearing retirement. If you are a family, if you're in your 30s or 40s, you start having a family, you start having assets, that's the right time for you to put a plan in place. All right. Nobody knows the time they're going to pass away. So no one is guaranteed eternity. So you can say you have plenty of time. That's our desire, but that may not be. I don't have enough, or it's for the wealthy. If you have a modest amount of assets, then it's right for you. All right? And a will does not resolve everything. It's good to have a will, but a will may not be enough for everybody. So, why are you here today? Can someone tell me why they're here today?
Well, we're interested in having a will.
Okay. Thank you.
I'm interested in finding out more. Trust is better than a will.
Okay. Okay. Are you together?
Oh, yeah, that's why I'm paying attention.
You're paying attention. You're here to learn. All right. Thank you. So, if you want to have a total assurance that you're picking the right people to make decisions for you, and that your family will not be in a confused state, and the comfort of knowing who will get what, or how your assets will be distributed after you gone, and that your family will have a peace of mind. Your family will have peace of mind that you created something for them to give them peace of mind. You're here for the right reasons. All right. Also, if you want to have peace of mind that your assets will not be lost to the government, but it's going to go to the people you want, then you're here for the right reasons. Also, everybody knows that this country loves taxes. Am I right?
Mhm.
We get income tax, property tax. What other taxes do we have?
State taxes.
State taxes, federal taxes. In estate planning we have inheritance tax, estate tax,
Sales
probate
tax.
tax,
Death tax.
death tax. So, as humans, we want to minimize, if possible, on how much we are giving away in taxes, if possible. With estate planning, there is a way you can make plans so that you don't give away so much in taxes just by putting proper plans in place. Do you understand? So if you want to learn more about how to save on taxes, estate taxes, then maybe you're here for the right reasons. All right? Also, estate planning is not about death only, afterlife only. It's also about while you're still alive in the event of incapacity, who will take care of you? How will they take care of you? If you are concerned or if self-care is something important to you, then you're here for the right reasons. Because I say that everybody, people are not mind readers. You know, some people are not good at mind reading. You know what you want for yourself, but your spouse may not necessarily know everything you want for yourself. Your children may not know what you want for yourself. Am I right? But if with planning you're able to document who will make decisions for you, how they'll make decisions for you, you make life easy for that. And that's part of estate planning. All right? So you make your choices and your choices will be honored. So do we have another important thing that we want to know is that as I spoke about our assets, a lot of us we've worked so hard over the years and we've accumulated assets. But people that don't plan or people that don't have things in place may lose their assets to the government. In Maryland, we have somewhere called Department of Unclaimed Properties. And you know how much assets go there every year? It's it's like $700 million worth of assets every year
In Maryland
in
alone?
Maryland alone. Over the period of time since it started, I believe about 1.9 billion or 190 billion worth of asset is in that department.
Wow.
Why? Because people have, let's say, a bank account, life insurance, investment account, things like that, bank account, but their families don't know about those accounts. After some time, the banks will just give it to the government until someone shows up to claim them. So it's important for us to make sure that our assets are not lost to the government. And with our estate planning, we help you to sit down and marshal all your assets, you know. And through our family wealth planning session, one of the things that will happen is that you will become financially organized because we'll make sure that you document more you have, you'll do some exercises. You'll think about what are the things I have, and you'll write them down. If something happens to you, your loved ones know what you have and where to find them. And it's so easy to lose assets. All right. That happened to me when I was putting my plans together. I prepared my plan, and mine was the first. I had to do this exercise and went to search my name in the Department of Unclaimed Properties. When I got there with my name and information typed in, I saw I had something there. And I became curious. Well, what could it be? Is it a bank account I had a long time ago? What could it be? Out of curiosity, I completed the forms, went, and when I got there, I was told, "Oh yeah, you have a check. You have a check." I'm like, "I have a check." "Oh yeah, yeah, yeah." When I got there to see what check it was a check that was mailed to my house by the government, and unfortunately, I moved from that house to a new house, and then the mail returned, and because nobody was there to claim it, it went to the department. When I claimed my check, it was $500. So I became $500 richer. Had I not known about this, I wouldn't have gotten that money back. Do you understand? And that was like almost over 3 years after I moved. All right. So if you want to check about that, it's under the Controller of Maryland, um,
I
somewhere
think
around
they
there.
mailed something too. They mailed a book around to everyone recently.
Really, I didn't get that.
I wasn't in it.
I didn't get it. Well, that's cool. It's good to know that I did that. All those homes in Baltimore. I don't know if you're familiar with Baltimore, with a lot of boarded homes. There are people's homes. There were people's homes, that maybe the kids did not know about, or maybe the person had passed away, you know. So it's so easy to lose assets, and you want to make sure you don't lose yours. And during your estate plan, that's part of what you do. So if you want the comfort and the peace of mind of knowing that your family are settled, the peace of mind of not knowing that your assets is not lost, and even to whoever you want, and you want to make right choices, then those are right reasons to have a plan in place. So as a reminder again, have you completed the first part of the green worksheet? Please complete your green worksheet as we move along. So estate planning may be a big word to some people, but I want to break it down a little. When you say will, people know about a will. Well, that's the most popular document, am I right? But estate planning is not only about a will. There are a lot of legal documents that makes up the process. But what is estate planning? It's planning in advance and naming the people that you want to receive the things you have after you die, right? But a good estate plan is so much more than that. And if you got what I've been saying in the summary earlier this evening, you will find out that having an estate plan is more than just naming people who will have things after you. Am I right?
Yeah, DNR,
What?
DNR.
DNR? That's part of it.
Are you planning?
All righty. So, do I have any estate? All right. Do I have an estate? So on the screen we have, believe it or not, you have an estate. Everyone or nearly everyone does. All right. Because your estate will consist of everything you own. Your car, your furniture, your home, your life insurance, your checking accounts, your savings accounts, your investments, other real properties like rental properties and mobile homes that you have, your personal possessions like your coin collection, your stamp collections, your artwork, your what's not there, clothes, jewelry, digital assets. All those are part of your estate. Okay, and when someone passes away, they'll ask, "What do you have?" A lot of people say, I just want a will. I don't have a lot, you know. I just have a home and one account, and I want it to go to my son. By the time I sit down with those people, I find out that they have a complex life and estate. Why? Because they have all this. But it doesn't come to their mind that their cars are part of their estate. It doesn't come to their mind that their furniture, their clothing, their shoes, their Gucci bags, their Louis Vuitton return, what else? Their four coats are all part of the estates they have. Do you understand? So from this, no matter how large or how modest it is, you have it. Almost everyone does. So who has an estate among us? With a raise of hand. Do we all have an estate?
Yes, sir.
Yes. Who doesn't have one here? I don't think so. To make it, even the young adults, somehow they do. All right. I had a daughter. She was 21. Unfortunately, she had an accident and she passed away years
Sorry.
ago. Thank you. So I had to go through to the probate court. And I was like, what does she have? I don't think she has anything. But we had an insurance and there's this PEEP coverage. Do you understand? And for us to get a PEEP benefit, we had to get a letter of admin. So, what was our estate? Maybe our clothing, you know, a bank account with just a little money in it, and that PEEP insurance money that we were going to get. So, a 21 years old daughter then had an estate. Do you understand? So, um, we all do, even if it's modest. So the estate planning is not only for the wealthy, it's for everyday people. So we've spoken about a lot of things that could constitute your estate. Your monies, your 401ks or retirement accounts, your home, your bonds and stocks, life insurance, etc. So my question to you will be, please write down on your legal pad, piece of paper, who needs your protection or what needs to be protected. Please write down who needs your protection. If you're online, you can type who needs your protection. For me, it's my family, my daughters, my husband. A lot of us walk, I would say, in where I come from, they'll say we work because of our children. I don't know whether it's like people say that here as well. Say, I'm walking because of my children. Is that the same adage here?
I think so,
You
yeah.
know. So, well, for now, I'm working because of my children and my husband. They need my protection. All right. But even much more, we have monies as we grow up those monies needs to be protected to you and given to our loved ones, not to the government.
Right.
So write yours. We'll get back to it later. So because a lot of people have a negative mindset about estate planning or having a will or a trust or putting things in place to protect them in the event of incapacity or passing away, I want us to have a mindset shift, okay? Because it's a better deal. You can get a new experience with planning. First of all, when you plan, you will be making informed and empowered decisions. You will be making that decisions and not someone else. Secondly, when you plan, you'll be saving your family thousands of dollars if you plan properly. Thirdly, your assets will not be lost upon death. Your family will be protected. Your family's money will be protected from outsiders, creditors, um, predators, people that pray to get what you have. When you plan, when you plan right, all right. And also, you may choose to keep your family out of court and out of conflict when you plan right. Some people have, some people plan, but their plan doesn't work for them. Some people don't have plans at all and they end up in court and mess and conflict. Am I right? And we hear stories of siblings and parents, just fighting each other. And some people even have a will, but they end up suing each other in court because one child does not believe the will was properly executed, or maybe someone thinks there's an undue influence, you know. But doing the proper thing and having a right mindset around planning gives you some of those experiences and benefits. At the end of the day, the goal for us as estate planning attorneys and the goal for you should be your plan should work when your family needs it. Some plans don't work, some don't, but this should be it. And why doesn't the plan work? For those who have a will or a trust or done an existing plan, when was the last time you reviewed your plan?
I haven't been very good.
So what we realize is this: people will create an estate plan like a will, okay? And when it's done, it's checked off, done, and they put it on the shelf, or they put it in their safe deposit box, or where they keep important documents, and they don't look at it for years until they pass away and someone looks for it and finds it. By that time, they bring it out. You know what happens? It may not work. And why wouldn't it work? Their life would have changed. The beneficiaries may have changed. The agents may have changed. Or maybe some of the agents have even passed away. Maybe the assets have changed because they've sold some things that they gave to some people. And the law too could have changed. I know someone that did a will 15 years before she passed away. And she kept it, locked it up. All right. And she had 2 houses and 1 bank account then, and she had 3 children. Okay. 1 house to child 1, the second house to child 2, the bank account to child 3. And she did a specific distribution for all of them, as I just said. 15 years later, she passed away. She had a will, am I right? But now, when it came to distribution, the person that she gave the account to was supposed to be the personal representative or executor. By the time she passed away, the bank account was already closed down. She had already sold one house. She had only one house left where she was living. And so, two children were unintentionally disinherited, and only one child got something. Was that a desire? Was that what she wanted? Really?
No.
No. And to make the matters worse, the person that got the house doesn't she the person wanted to continue to stay in the house. Okay? So she's not intending to sell it or to share proceeds with the siblings. And to make matters worse, the person that is a personal representative didn't get anything. So he decided not to do his duties as a personal representative to make life difficult for the sister. All right. At the end of the day, they ended up in litigation because the sister needed to get title to the house. The mom planned, didn't she? The plan work for her when needed? No.
But did the will, that's what she wanted her to have? I mean, really?
She got it.
Okay.
She got what she wanted her to have, which is the home. But what about the other siblings? They're not getting any.
Sounds like she didn't care.
She cared then, but she did not review a plan.
Well, I mean the mom. I mean the
Yeah,
sister
the
who
mom.
the sister who had got the house
Mhm.
didn't care whether the other two.
Exactly.
Yeah.
She didn't care what happened to the other two. She was going to live in the house. And how would the other people have, she could have refinanced or something and given some money to the others, but that wasn't her intention.
That was the executor of the will, is that what you're saying?
That was well, the will did not work. What I'm trying to say is this: the mom's plan did not work because she did not review a plan over the years. Do you understand? When she sold the other home, she didn't make a change, even though she made a specific distribution. So, when was the last time you reviewed your plan? You need to review estate plans regularly. We recommend at least every 3 years. Okay. So that you will know that everything is going to work. So if you don't have a plan at all, that's even worse. If you don't have a plan at all, the state has a plan for you.
Oh, they do.
They do. And who knows what the state's plan is? Do you like it all the time? Maybe not. And let me tell you what the state's plan is. It's called guardianship in the event of incapacity or probate
Right.
in the event of death. So, when people become incapacitated in Maryland, there are some decisions that your close relatives cannot make for you. Do you understand? There's some things that they can do for you, take you to the hospital, but when it comes to major decisions, like if they have to pass through a government entity, they're going to ask for a power of attorney. Or what legal authority do you have to act on this person's behalf? Or if they go to the bank, they can't take money out of someone else's account. But from now that we have ATM card, if you know the PIN number, but then we used to have checks and, you can't just go and withdraw money from someone's account if you're not authorized to do so. So, there are a lot of things that people want to help their relatives and incapacitated loved ones to do, but they can't because they're not legally authorized to do so. And here we have this person incapacitated. Maybe they had an accident and they're stuck in the hospital, or they're in coma and they can't talk, they can't walk, their life needs to go on. The bills are the bills needs to be paid.
They never stop.
It never stops. So these people who are your relatives will have to go to the courthouse to be nominated as guardians. Guardians over your property, guardians over your assets. Property is asset, and guardians over your person. All right. In Maryland, it takes about 3 months to get before a judge. So sometimes 3 months could be like forever. Even 1 week could be like forever in certain situations. Why? All because people don't plan ahead on who should represent them in the event of incapacity. All right. Is that something you really want to happen to you? No. You want to plan ahead. So, another thing is that when they get before the judge, there could be more than one person wanting to take care of the person. All right. So I've seen a situation before that 2 loved ones, a father and a daughter, were litigating about who should be the guardian for the mother, because the mother couldn't help herself and the father wasn't in good terms with the daughter, and now they were fighting in front of a judge. Why? Because the mother did not decide who should represent her. So all these things are dramas that we see happen, and I don't think they're good situations. When we can avert such, we should, by having legal documents in place. And probate is where people go when their loved ones pass away. In Maryland, it's called Register of Will or Orphans Court. Okay, so the same situation of conflicts can happen because people don't plan in advance to choose who their executors or personal representatives will be. Also, when you get to probate court, this is the plan of the state for you. You see this tap for now? That's the state's plan. They're gonna ask, what do you have? They say, what do you have? Then Mr. Lawyer, attorney will get the attorney's fee if the representative hires an attorney, because the process is complicated sometimes. The executor may spend money, trying to get things in place, and they spend time too. So they're entitled to about 3% of your estate. If you have a home, it has to be appraised. Both the personal properties as well as the real property. The appraiser will take his fees. The court will take filing fees. The creditors, that's the hilarious thing, all right? There's going to be a newspaper publication, not once, but 2 times, saying Mr. X passed away. If he owes you money, show up and make a claim. It doesn't make sense to me, but that's the process. So creditors will come and take their pie of the cake. Bonds, everybody will pay a bond fee, even if you say you waive bonds. All right. At the end of the day, all these people will take a piece of the money of the deceased person before their beneficiaries will have the remaining. Is that what you want, the state's plan? Is that the best thing? No. But if you don't have a plan, it's like planning to fail or just exposing your money for every other person to take apart from your beneficiaries, right? Going through the court system. And so the probate process is like filing a lawsuit against yourself with your own money for the benefit of your creditors. It doesn't make sense, but that's it. For those who don't make plans ahead and making sure that their plan works for them. So, that being said, we want to take precautions. We want to take actions to make sure that as much as possible, we even don't have to fall as victims of the state's process. And we want to take our lives into our own hands to do the right things for ourselves and our beneficiaries and our loved ones. All right. So this is a summary of Maryland probate. Maryland probate number one is public. And what does that mean? For those who have a will, the will, when the person passes away, you'll have to present the original will. And then the will will be put on public record. All right. Anybody can see it. If you go to the courthouse, you'll see a copy of the will. Or even online, if I request for one, I can get it. All right. So a lot of people prey on this situation. Like those who do estate sales, like those who do credit card companies, like those who even realtors. A lot of people prey on this information because they know who your beneficiaries are and what you're giving to who. So, do you want to make a plan that is now public, that everybody knows what you have and what you're giving to someone at the end of the day? Maybe not. When you can do better, there's an opportunity to do better. All right? Also, the probate process in Maryland takes between 12 and 24 months for a regular estate. A small estate for one person is less than $50,000. A regular estate is more than $50,000 for one person. So, the process is complicated. So, your beneficiaries, after the distribution and all that, and the accounting and the inventories and all the process, will have to wait to really get the judge sign off to close the estate and title will pass after 2 years for some people. Some people get a lot of complexities in between, litigation, people fighting and biting against each other. You know, would you want your relatives to have to wait for 24 months to get what you worked hard to give to them? Maybe not. Would you? No. I wouldn't anyway. And also the cost of probate can be enormous. With all the fees I just showed you in the chart, in the tab, in Maryland, it could be up to 5% of your asset.
Yeah, I saw that.
So, there was a piece of land. Someone had a piece of land that was part of their probate, their estate. Okay, the piece of land was worth $1 million. The attorney's fee alone was $37,000, and it's a statutory fee. Okay, so now the executor or personal representative can decide to say, well, I worked so hard on this person's estate. I want my 3%. Was 3% of 1 million. Maybe another 30,000. You understand? And so on and so on. So, but if the person had properly planned, they'll save themselves or minimize at least what's going to these other people unnecessarily. For those, I told you probate is public. These are examples of public probate. That's the will for Jackie Onassis, Jackie Kennedy. We had stories about people that did not do their estate plans properly. Aretha Franklin, people that had to go to court, Chadwick Boseman. Do you understand? But we expect these people to know better. If they did not, then other people probably are in the same situation, but you don't want to be part of the story. All right. So, with all that said, I want us to go to our green worksheet. We learned about probate being public, probate, the cost of probate, and the third one, the third point, the time. If you have the opportunity to keep your family out of court, would you? Yes. Okay. If your answer is yes, can you check the first box? I want to keep my family out of court. That's please tell us about your needs, or please tell us about what relates to you. I want to keep my family out of court. All right. How many of us have children under 18? None. For those online, if you have children under 18, one of the things that happens is that beneficiaries, or even over 18, if you don't plan properly or you just have a will, beneficiaries will get their assets, what you give to them, inheritances, outrightly and unprotected. Okay? And for those who have minor children, they get those once they turn 18. So let's assume you have a home, and your home is $500,000, all right? And you have a child under 18. Would you want to give $500,000, and the house is sold? Would you want to give $500,000 outrightly to your 18-year-old child? No. What will they do with it? Spend it anyhow. You know.
Have more fun than we did earning it.
That's for sure.
You know, for those who have not completed their education, it's not going to be going to college will be useless to them, because they're like, what's the point? You know, I'm going to college because I want to earn some money, you know, work in a good place and earn some money. I have the money already, at least for the next few years. So why? So, but you want to avoid a situation where beneficiaries receive their assets outright and unprotected. There was a person that his father died. The father left him $50,000, and you know, God just got it and squandered it. He didn't go to college, all right. And years later, it was like that $50,000 vanished within a year, all right. And I also have another situation for unprotection. If it's not protected, this person, a father left her $150,000. She got married. She was married when the dad died. So the $150,000, she just kept it in an account, which happens to be a joint account. After a few years, the marriage collapsed and they had to go through a divorce. And when they got to the divorce court, the judge permitted the husband to have a share of that money, of that 150. Why? Because the money was commingled. She got it outrightly. It was hers. It's now theirs. It was now a joint property asset. So, at the dad giving her the money in a trust and she put the money in a trust, the husband wouldn't have had part of it. She could have used the money to set up a accounting firm or maybe buy a rental property or do something else that wouldn't have to commingle as a marital fund. So when you're giving assets to people, you want to know, is it for the son-in-law? Do you want the son-in-law to have a part of it? If no, you have to plan better. Rather than just have a will, have a trust. You can have control, a lot of control, if you have a trust in place than having a will. All right. So better planning thinks more about what do you want the beneficiaries to use these assets you give it to them for. So with that said, this may not apply to us because we don't have kids under 18. But if you need to make, the third one says, the second, for those online, the second says, I need to make sure my kids don't inherit at 18. So if you have a young one under 18, if something happens to you, would you want them to inherit at 18? If that relates to you, type yes. The third point says, I want to ensure that my children's inheritances are protected from creditors, lawsuits, and future divorces, no matter what. If that's something of interest to you, based on the story I just told, check that box. I want to make sure my children's inheritances are protected from lawsuits and creditors and future divorces, no matter what. Check that box. All right. So how old do you know your children? Do we all have children, adult children at least? All right. How well do you know your children, or how well do you know your siblings? In Africa, where I come from, this is so bad. But I think maybe the culture is changing. But it used to be that when someone passes away, let's say the head of the household passed away, the family members will come and take the things the person has in the marital home. Take it away. They say it's my brother's stuff. And leave the family to suffer. Sometimes they even, it's a bad tradition in some parts of the country that they now tell the widow to go and get married to the deceased sibling. It's so bad because they think the widows are assets, But that being said, if the person properly, you don't know your siblings. That's what I'm trying to say. You may not know. When it comes to money, you don't really know people that well. Have you had to play the game of Monopoly? Are we familiar with that game? That you have to buy a house in Piccadilly and Potomac on the board. It used to be fun then, because then I didn't know where Potomac, Maryland is. But I knew that on the Monopoly board, when we're playing Monopoly, it's one of the rich places in the United States. that I knew that the rich people, the big houses or land or something, you can find them at Potomac. I don't know where that is on the map, but I knew it was on the Monopoly board. I don't know where Piccadilly is. Who knows?
London.
Right before you pass go.
But what I'm trying to say is this. Imagine how much conflict happens when you play Monopoly, because you have to get some money or assets. Now translate those into real life situations. When it comes to the matter of money, you don't know how people will behave. The good person may become the black sheep of the family, you know. So when people don't have plans in place, then just leave a lot of people at risk and drama and conflict.
Yeah.
If you do something well, it may be a good situation. They'll be jolly good fellows. The children will like each other if the parents plan well. It may be a situation that they'll end up in court because it's a matter of money. My brother took all the money, my brother changed the wheel, nagging against each other, fighting. The entitled child, or we need to divide this house with 5 children, then we have to cut the house into 5 pieces. These are situations that can happen when people don't put proper plans in place. And because we have foreknowledge that these can happen, we want to make plans, estate plans ahead to alleviate such. And we want our plans to work when it's needed so that all the people are doing is implementing it. So you're not doing DIYs, do it yourself will, online will, Rocket Lawyer, Susie Orman's will and trust, Legal Zoom, because most of those lead to this situation. People, because they don't have enough money, try to just go online and prepare legal documents themselves, but they don't understand the legal intent. So don't do DIY estate plans. Go to a lawyer, an estate planning attorney, not even a general practice attorney, not a door-to-door attorney, an estate planning attorney that knows what they are doing to get your estate plans in place. It may cost you a little more, but at least you know that you're getting the right thing. And also, not a document-only attorney. You know who the document attorneys or traditional attorneys are? I need a will. You tell them what you need. I need a will. Am I right? And then they'll ask you, what's your name? Your kid's name. Who do you want us to go to? Then now you're a couple. Am I right? They now prepare a boilerplate will for you, or a boilerplate legal document, whatever it is. And the legal document, aka the will say, I give everything I have to my wife. And the wife's one will mirror it and say, I give everything I have to my husband. Am I right? Which could be okay. But do you know life happens? So I have a situation, but the boilerplate wills don't necessarily answer the specific situations of your life. Do you understand? So don't buy Staples will because your life is not a boilerplate. Do something that will be crafted for your family, for your specific life and needs. So what happens when you do traditional lawyers one? They'll prepare the document. They'll send it to your email. Please review and get back to us. Review and sign. But that thing stays in the emails forever and ever and ever. Amen. Because you don't even understand what it says. The people don't understand what it says a lot of time, or they don't even have enough time to execute those documents. So what's the essence of paying a small fee and not getting the job done? They just give you document only. You don't want that. You want people that will make sure it's crafted to your need, it's executed, and it works. So I think I made my point on that. We spoke. Am I going back? Sorry. All right. I'm not going to touch on this because the people here don't have young children, okay? But for those online, if you have young children, there's something called Kids Protection Plan. And just having a will may not protect your children in case of family emergencies. So you need to make plans and nominate both long-term guardians, which is in the will a lot of times, and short-term guardians for your children. All right? Now I want to talk about in the event of incapacity. We spoke about that earlier, that people that don't have plans and they become incapacitated need to go through the guardianship court. Can we remember? Did we remember that? So, my question now will be, do you have a healthcare directive or do you even have a power of attorney? Those are two legal documents that are used for incapacity. The power of attorney is used in the event of for financial and everyday life. The healthcare directive is specific to for healthcare. Who will make healthcare decisions for you when you cannot make one by yourself? Or who will run your everyday life if you're sick in bed or if you're out of the country and you need to sign a contract? Do you have the legal document in place for someone else to do that for you? I don't know if you know Terry Shivel, but she was popular in the 90s. Terry Shivel became sick and she became brain dead. All right. She didn't have any legal documents in place saying who should make decisions for her. So, and she had loved ones. She had a husband and she had parents. And that happens to many people. They have parents, they have children, they have spouses. All these people are very close to you and they're interested people. Am I right? They have your interest at heart, but they have various opinions about what should happen. Am I right?
Right.
So, Terry's parents, I believe, wanted her to continue on life support. And Terry's husband wanted her out because she became a burden.
Yeah, right.
Do you know that there was so much conflict between the two of them that they had to go to court on what should happen? And they didn't stop at their local court. The case went all the way to the Supreme Court. Do you know how many years this case was pending? 10 years. 10 good years. And this lady was left on life support for that period of time. Why? Because she didn't make a simple legal document saying who should make healthcare decisions for her in the event of incapacity. At the end of the day, the judge ruled that she should be taken off life support, and she passed away not too long after that. But do you know how many thousands, hundreds of thousands of dollars would have gone to litigation or medical care? So all these things are important. I told you that nobody is a mind reader. Am I right? So just take Terry. Somebody wanted her to pass away, and the other person says no. And they began to fight one another because they both love the person. You want to avoid conflict, number one. Number two, you even want to make these decisions by yourself. Do you want life support or no? How do you want to be taken care of in various situations? Do you understand? Someone spoke about DNR, do not resuscitate. Do you want that or no?
No.
Do you,
All matter of life.
you know,
Like quality of life.
so you want to have a healthcare directive in place and make those decisions ahead by yourself so that people are giving clear directives on what you want, and they're not making their own decisions for you based on what they want. Do you understand? And that makes life easy. You turn your wishes into directives. So, and there's some people, a lot of people don't have a healthcare directive or a power of attorney. And there's some people that have it, but it's outdated. So they need to make new ones. For example, an outdated one may have, let's say, back to the spouse situation, you make your spouse your first healthcare agent, and the spouse passed away. Am I right? And a lot of people just name one person because they're not doing it right. So who will be your agent if the spouse has passed away? No, that means the document is outdated. So we want to work with people, legal attorneys that know what they're doing, so that they're telling you name more than one person, name an alternate agent and things like that, so that your plan will work for you. So if all that I've said resonates with you, and you think you need to have a power of attorney or a healthcare directive, or maybe you need to review one, please check your green worksheet. And if you're online, type, I need to have a power of attorney, or I would like to have a healthcare directive. All right. We've touched on a whole lot of things, am I right? And earlier on, I mentioned that a will does not answer everything. Am I right? That one of the myths is that people think a will answers everything. But that's not true, because through this presentation, we've seen what could happen. All right. A will, I don't know if I mentioned it, but if you don't have any estate plan, you go through the probate court. If you have only a will, you still have to go through the probate court. All right? And you see what will happen when your people go through the probate court. If you want to avoid the probate court system, instead of having a will, you want to have a revocable living trust. Okay? And not just the document, because people are always looking for cheap. Do you understand? They have a revocable living trust, they sign it, they put it on the shelf. But no, just having only a revocable living trust signed will not work. You need to have a fully funded revocable living trust. The only foolproof way to avoid probate court is to have a fully funded revocable living trust with disability provisions. What does that mean? Fully funded means you transfer the titles of your assets from your personal names to the name of your living trust. Because anything you hold in your personal names go through probate. All right? But anything you hold as a joint asset will not go through probate. It will go to the surviving owner.
Yeah.
So if you have a home as a jointly titled home with right of survivorship, that if one person passed away, the title to the home automatically goes to the surviving spouse. All right? Or if you designate beneficiaries, for example, on your life insurance, if you write a beneficiary's name, it goes to that primary beneficiary. So those avoid probate. Those are non-probate assets. All right? Or the same with a retirement plan. If you name a beneficiary, it goes to the beneficiary. Those are non-probate assets. But they're probate assets. Anything in your personal name goes through probate. So, for a thing like a home, how many of us have homes? Like, you have a home in your name. Okay. For a thing like a home, a lot of us are not inclined to put our children's name as joint owners. Am I right? No. So, what we need to do is to put that home in a living trust. Do you understand? So that it passes to them after you're gone, like, oh, like a distribution to them, like you do in a will. So a trust, while you're alive, it's all yours. After you're gone, it acts like a will, but without the court's involvement. So the way to attain this is change the title of your assets from your name to the name of the living trust. That's called funding. So you don't leave things out when you're funding. We mentioned different types of assets, am I right? So all of those things need either to be funded into your trust or properly designated if they're non-probate assets. All right? So what are the things you do to fully fund? Retitle investment account, sign a new bank card, execute deeds for your real property, transfer stocks and bonds, assign your personal property, change life insurance and retirement account beneficiary designations. So, if you're doing a Susie Orman's trust, it's going to give you the document, but it's not going to help you fund your trust. And the cute thing is not cute. They'll tell you, please go and show this legal document to an attorney. And I've had a couple of people bring those documents to me, and I look at it. First of all, these people drafted it themselves. They're why. Secondly, they're telling you you're paying for this, and they're telling you go to a lawyer to make sure the right thing is done. So why are you doing it in the first place? Do you understand? So go to someone that will do things for you right and make sure that your trust is funded if you're having a living trust. Fully funded. So that none of your assets will be left behind. I know someone that had a trust and paid $3,000 for that trust. Okay? At the end of the day, when he passed away, the children had to still go through the court process. Why?
Wow.
Because he did not fund the trust. He did not put his assets, all his assets, in the trust.
Went to probate instead.
Yeah. So don't wonder, my dad tried to do all this right. He has the document, but the document did not work for us because he did not do the right thing all the way. And to make the matters worse for that family, the dad remarried. So he had an ex-wife, and the ex-wife's name are still on some of the documents as people, she was still going to get something in the will, though she's an ex-wife. Why? Because it did not review the estate. It did not review those documents after he got a divorce. So when there's a major change in your life, you need to review your the estate planning document. Do you understand? So he spent $3,000, but it did not work for him because he did not fully fund his trust. So, in our office, we help you to get things done right. First of all, if you have a living trust, it helps you avoid probate. It saves time. So instead of your things being stuck in court for 12 to 24 months, things could be, the estate could be administered in as short and as quick a time as your trustee, your successor trustee wants it to be. 3 months, 5 months, and things get settled outside of the court's involvement. Number three, you'll save a whole lot of money. Am I right? Because a trust is a private document, not a public document. And you save on estate taxes because there's so many things you can say in your trust and so many ways you can plot it so that estate taxes are saved. Number four, your kids, you can decide that you're not going to give your stuff to them outrightly, but in ages and stages. So let's say you have so much money and your kids are just in the middle age, let's say in their 20s or something like that. You can say, I give part of it to them to this person at 25, 30, 35, however you want it. Or even tell them, if you have young children, put things in trust for them. Or even if you have adults, put it in trust for them so that it's not given to them outrightly and it's protected. And you can tell them as well that I want you to use this money for education. I want you to use this money when you're getting married, whatever you want. So having a revocable living trust gives you a lot of leverage. All right? And if you have the opportunity to have that done rather than just have a will, you want to take that. So that being said, if you go back to your worksheet, if you think or if what I've said resonates with you and you want to say, I need a living trust, or maybe a will, in this case, a part over will if you have a living trust. Or maybe you want to review your existing plan. Please check that box. You want to have a living trust, or you want to have a will, plan, basic, or maybe you have a plan in place that you need to have a review. Please check that box. I also mentioned something about saving on estate taxes. Am I right? So if you think that you have so much and you want to save on estate taxes, then you want to check that box as well. Because things can be structured in your trust in such a way that you wouldn't have to pay so much. Prince, when he passed away, there was so much in estate taxes that he paid millions of dollars. Why? But if he had structured things that had various trusts that holds certain amounts of money, it would have avoided some unnecessary taxes. So if any of those two resonates with you, having a fully funded living trust is not done where you just have a document only. Okay? It's done by people, attorneys like us, that will make sure that you fund your trust when you create the document. And the main essence is having a revocable living trust. But what if I tell you that you can have your trust, but everything you have is not going to be yours? Would you like that? So a revocable living trust makes your assets still yours while you are alive. And after you're gone, it acts like a will. Okay? But there are other types of trusts, like an irrevocable trust, that takes the ownership from you completely while you're alive. Because because of creditors and all that. Is that something you like? Maybe, maybe not. Do you understand? But I know that a lot of people want to have control over what they have while they're alive. So we'll know when you speak with us, you'll know which one suits you better. All right. I also got some people that needs to take care of their pets.
Mhm.
You can make decisions and provisions for them in your trust. I know those are special needs children. We can make plans for those as well. All right. So we told a lot of stories today, a lot of situations. Am I right? So, but there's some people that do things right. Am I right? Not everybody does their estate planning wrong. So this story is about how to plan for success, the anti-story, a person that did it right. So Jackie, that's what I'm gonna call her. Jackie is 37 years old, in her 30s. Okay? So she has two young children. One was like 13, the other was 15. And because she's still growing, she has a home. She spoke with a financial advisor who advised her to have life insurance, and she got it. I told her she has a home. And also, she was told to have an estate plan done, and she decided to have a revocable living trust and also funded a trust. So she put her home in the trust. She also did what we call the kids protection plan to nominate guardians for her children because they were under 18. She had an accident and she had to be in a coma. She was in coma. She did a comprehensive plan. So she had a power of attorney, healthcare directive, kids protection plan, will, leave trust, and a whole lot more. She was fully covered. When she fell into this situation, while she was still in coma, a healthcare directive came into play. And her sister could come in and make decisions for her about her healthcare and help, just implement the decisions she had in her healthcare directive. She had to be on life support. So she said that she wanted to be on life support for 2 weeks after all medical things were done. So that was what happened. She had a power of attorney and needed to pay her bills. Her sister was an agent, so her bills were paid. She had a kids protection plan, which nominated a short-term guardian and a long-term guardian. So a neighbor was the short-term guardian for kids. So the kids stayed with a neighbor who was authorized to take care of them while she was in the hospital. And they could still continue to go to school. And the CPS did not have to pick them up because nobody was on because she covered that situation. Unfortunately, she passed away. So her sister was the long-term guardian to her children. And instead of custody litigation between sisters, she already said who she wanted to take care of her children. So one of her sisters, took care of the children as a long-term guardian. A long-term guardian is only in a will, so she got covered. A life insurance had beneficiaries, and the beneficiaries were the children. But the children were still under 18, and they couldn't have those lump sum. But she had a trust, so those money stayed in trust. And the trustee was able to help manage those monies to fund the kids' education and health and all other things they needed before they grew up. She didn't have to go through probate, and everything was resolved within 3 months in terms of putting things in proper place. And she gave peace of mind not only to her sister, but our kids got what they wanted, but well taken care of without the court's involvement, with less cost. And all because she did things right.
Mm-hmm.
All right. So that's a story. It's not a drama. Am I right?
Mhm.
It's not a drama story. How many of us like watching drama? Well, we don't want our life to be a drama, you know. So don't create drama in your family by not doing things right. Just let it be well with them. Don't create a mess for that. Do you understand? So do things right. We're almost wrapping up. So one of the questions of interest to someone that wanted to learn about a will or trust, when do you need what, which one? Am I right? So this may be of interest to you. When do you know whether you just need a will or whether you just need a trust or whether you need a trust and not a will? Number one, if you have assets over $50,000, you may need a trust. Okay? If you have a home or a real estate, you may need a trust, not a will. If you have minor children, you'll need a trust, not a will. If you have a blended family, like the story I told about the father and the daughter-in-law, you need a trust. Why? Because some people they disinherit their out of marriage children unknowingly. If you have problem children, who have issues with substance abuse and things like that, you need a trust. Or if you have children with special needs, you need a trust. If you have a business and you're a business owner, it's better for you to have a trust and not just a will. All these and much more, but these are some examples I could give you. So if your life situation falls in any of this, you may need more than a will. You may need a trust. But how do you know what you need specifically? Sit down with us in a family wealth planning session, and we will talk one to one based on you, your family, your assets, your desires, why you want to plan, and then you know what you need. Okay? I will invite you to do so. So our topic today says 3 mistakes people make in estate planning. And I want to ask us questions. From everything we've spoken about today, what are the 3 mistakes people make when it comes to estate planning that you learned about? Can you tell me, please?
Well, one of the things, not having beneficiaries on your accounts,
Yes.
not having a power of attorney.
Yes. Any other what person?
Excuse me?
Does any other
Not
person
having a
want
trust.
not having a trust? Yes. Any other thing? Well, we've mentioned 3. Thank you. Trying to create these plans by yourself. That's another mistake people make. Or naming children, minor children, as beneficiaries. That's another mistake people make. Or not naming people at all. I know someone that had a life insurance and did not put a beneficiary's name. So these are much more. There's a lot. There are a lot of mistakes people make, but those are some that we mentioned. If you're online, please chat. Um, what mistakes do people make when it comes to estate planning? From all the stuff we've spoken about, can you put it in the chat what you learned or what you know, or what you want to share with us? Thank you. How will you avoid those mistakes? Can you tell me one or two ways you can avoid those mistakes?
Work with more than one. Work with your family.
Work with your family,
One decision.
something like that. But
These are
much
going
more.
important for
Yeah.
probate.
To avoid probate. Avoid probate. Yeah. Any other person? How can you avoid? How can you avoid those mistakes?
Well, signing on beneficiaries on your accounts.
Yes.
Know your assets.
Know your assets. Yeah. And don't try to do these estate plans by yourself.
Mm.
Don't DIY them. Use an estate planning attorney, someone whose specialty is estate planning. Do you understand? Not a general practice lawyer. So, do you have any other takeaways from today's seminar that you want to share with me? No? All right, we discussed some already. Am I right? Thank you. So, we want to make it easy for you. And how do we start? If you're interested in having an estate plan, you've learned a lot today, am I right? You start with our office by having a family wealth planning session. That's our strategic meeting. It's a one-to-one meeting with you. If you're a couple, both of you come together. I will talk about you, your family, your assets, and what you need in form of a plan. And we find out whether you need a will or a trust or what else do you need to put in place. We are not a document only attorney. So if you need everything, we give you everything so that you're properly covered. Okay? But that process, if you don't achieve anything, it should make you more financially organized than you've ever been before, so that your assets will be kept out of the government's unclaimed property department. Because I explained earlier that will help you to make sure you gather your assets together. Also, when you return our services, you will be able to make informed decisions and choose the right planning level and fee for your plan. Okay? You'll make informed decisions about different things at the design meeting. You will know what the cost is. We have 3 planning levels, and also you'll be able to choose the right plan for your family. So I'm not going to be telling you, I'll tell you, these are the plans. Which one do you think it's fit for you? Our fees are flat fees, so there are no surprises. They're not hourly fees that you will know how much it's going to cost you at the end of the day. And also, you'll know that because you're using an expert, your family will be expertly guided, not only during your life, but in the event of incapacity or death, because we'll also help your loved ones if something happens to you. We create relationship with with our clients. We know their children because we create their plans. We know their children's names. So if something happens to you, I've had a lot of my clients' kids come back to me. What should we do? And we're able to guide them. Do you understand? Or even help them through the process. So a family wealth planning session is a 2-hour meeting. Okay. It costs $750. We are going to offer it to you if you do 2 things. Submit your green worksheet. You'll get a gift certificate for $750. However, you have to schedule that meeting. If you're interested, schedule the meeting with a $20 to secure your appointment, to get on the calendar, and also a commitment to complete the intake sheet. Do you understand? So we're going to mail to you an intake sheet. in a priority mail, and we're going to email it to you as well. We call it pre-meeting packet. You take it out, you complete the intake, and you return it to us 3 days before the meeting so that I'll be able to review the information and make the best use of our time. So when you submit your green worksheet, we're making it easy for you to have that session like almost free, okay? Because you'll have the certificate that you'll bring along. But if you don't complete your intake, that means you want to pay the $750, and we'll be willing to welcome that. So please complete the intake and submit it to our office 3 days before the family planning session, and make use of this when you come. But for you to get it, you submit this today at the bank and schedule with $20. Debit card, credit card, cash. Also, you're gonna make use of the when you schedule today, we'll give you the $250 coupon. All right, and that $250 coupon is a credit towards the service that you choose to do with us. If you choose a trust plan or a wealth plan. So your experience with us will not be hourly fee, it's going to be flat fee. You're planning ahead to avoid problems, not a knee-jerk experience to problems. And also, we are not a transactional, attorney is not a transaction with us, it's a relationship-based service. All right? Questions? Are you thinking about it? Please do not procrastinate. Do not leave your family at risk. We can help you get it done in the right way. All right? Because our goal is to make sure that your plan works for your family when it's needed. So don't procrastinate. Go to the back at the end, sign up for a family wealth planning session, complete your green worksheet, submit it. We'll get back in touch with you by mail, by email, okay? Or even phone call. So make use of our golden ticket today. Thank you very much.
Thank you.
So, if you have any questions at this time, I'll take it. Any questions? Did you jot down any questions?
Yeah, I'm happy. I enjoyed it. Thank you.
Thank you. Did you have your question answered, ma'am?
No. Me?
No.
Was thinking.
No, you at the beginning you said you want to know more about a will and a trust.
Yeah, and comparing what you had to say, it's clear that trust is necessary.
Yeah. So a trust is a more sophisticated legal document than a will.
Wow.
Alrighty. Thank you very much for those online that joined us today. We're very grateful. Thank you so much for your time. Please contact us. Our office, call 301-276-0887 or email at csd@ivylawoffice.com. We are looking forward to you scheduling a family wealth planning session. You have a question. All right. We're about to answer the question for someone online. Thank you.
They said, I read somewhere where the power of attorney was dissolved when the person dies.
Yes. The power of attorney is only for when someone is alive. All right? It becomes ineffective when the person passes away. So you need power of attorney for when you're alive. A trust or a will kicks off at death. So that's correct. Was that the only question? I hope you answered it. Thank you so much for joining us, everybody. We look forward to seeing you at a family wealth planning session. And if you have any private questions, you can come up to ask me.
Yeah, well, we have an appointment with you
All righty.
in April.
In April. All right. Have a good evening. Thank you. Did you enjoy the session?
Yeah, I thought it was